Hi everyone, Derek Johnson with Tatango.com. I'm here at Innovista Law, the home of the TCPA Defense Force. I'm speaking to Joe Bowser. He is a TCPA attorney. One of the questions we get asked all the time is what constitutes a marketing message? And we're talking about text messages here. What constitutes a marketing message versus an informational message? And why are we even talking about this, I guess?
Right. Well, let's answer the why do we care question first. The reason we care is because the TCPA sets up different levels of consent that's required to send a text message based on the content of the message. So we've already put ourselves in the universe of TCPA rules that apply to text messages, which are different than calls to residential lines, different than faxes, right? So we're in the TCPA rules that apply to text messages. The rules that apply to text messages distinguish informational and marketing calls, and the reason it's important is I need a higher level of consent to send a marketing message to a consumer than I do to send an informational message.
Okay, so it's harder essentially to get their permission to text message a marketing or sales type message than it is a informational message.
Exactly. Okay. So if the message is going to be deemed to be a marketing message, I need prior express written consent, which comes with a host of conditions, right? It needs to be obviously written. It needs to be signed. It needs to have disclaimers about which number you're allowed to call, that it will be via an auto dialer, that it will be a marketing message, and that they don't have to give you this consent as a condition to purchase or complete whatever transaction.
Not required to purchase something to give out the phone number.
Nor are they required to give their consent to finish the transaction.
Okay.
Right? So in any event, so you need that higher level of written consent to send a marketing message. But the way the FCC has handled the regular prior express consent standard for informational messages is you just have to be given their number in the context of why you're going to send them a message. Right?
Okay. Do you have an example maybe of that?
So you give your phone number to the airline. Right? Your flight gets canceled. They can text you about the cancellation. Right? I give my number to a school. They can text me to say, you know, school's closing early today. Fire's coming.
Because it's informational.
It's informational.
Not marketing or selling a product.
Exactly. But the line between informational and marketing is not always clear, right? So we've had a number of cases that struggle with where that line is because the level of consent that the sender had, it makes all the difference about whether there's TCPA liability or not. Right? So if the school got the number and they're sending promotional messages, hey, go to Joe's Pizza. Because it sends money to our PTA, because the PTA then buys our computers. They're really encouraging the purchase of a product, pizza. And so the ultimate purpose of that message is arguably promotional.
So it's kind of that gray area.
Right.
I was thinking like, you know, for airline, it's very obvious if they're marketing a new route, let's say to Mexico. That's marketing or sales. But then I guess there's informational, like if they're telling you that they have a new product on their plane and you're going on that plane, you might be interested in it and you should know because you're going on the plane, but it's selling you something. It's a weird gray area.
Or we're hosting an event. Come to our event. Johnny's going to be singing, but oh, by the way, Johnny's books are on sale. Right? You don't have to buy them, but you sure, you know, if the court finds that you hope that you buy Johnny's books when you go to Johnny's free book reading, the court could find that that's a promotional message. One of the early famous cases is one against Best Buy. Best Buy started texting its customers saying that, hey, it was called like a loyalty rewards program. Your loyalty points are going to expire soon.
That sounds informational.
Sounds informational, right? You could certainly make the case, and the lawyers did, but the court found that the reason Best Buy really wanted them to go to the store was not only to use the points, but hopefully use the points and then some.
Oh, wow.
Right? Because the point of the program is to get them in the store. Best Buy doesn't really get a lot when you just use your points, but you could see them going to the effort of sending messages to their consumers to get them in the store buying goods.
Interesting. So it seems like there's very clear, you're, you know, a burrito place and you're sending text message coupons for a burrito. Sales and marketing.
Obvious.
Informational, there's an emergency at the school, come pick up your kid. That's pretty obvious.
There are other exceptions for that. But
And then there's the middle kind of ground, which it gets kind of gray. What would you advise somebody that maybe wants to play in that gray area? Should they consult an attorney? Should they always get the sales and marketing opt-in rather than just informational?
Well, so I mean, two things there. Consulting an attorney is certainly a good idea because you'll see where the law differs across the country, because the courts are not consistent in how they apply these dividing lines between informational and
so you're saying, like, if you're in Seattle or New York, it could be interpreted differently.
Exactly. So the circuit courts in those territories could have very different rules, and often do, around what's an informational versus. So the Best Buy example I gave you was from the Ninth Circuit that governs California, Oregon, Washington. So whereas other circuits have taken a more kind of just defensive position around what constitutes an informational call, where it's easier to get into the informational bucket.
Interesting. So it's not as easy as, like, we're like Best Buy, they were okay or not okay, so therefore we're okay. Like, it really depends on a lot of different factors and where you're located.
Right. And well, so the second point that you made was, should I just get that higher level of consent? That belts and suspenders approach is a good approach.
Okay.
Right? Because then, if it happens to be that the court says, well, that's a marketing message. Okay.
You have the highest consent or opt-in, that you could get.
Exactly.
Okay.
Exactly. So that is belts and suspenders.
Okay.
But there are costs to that, right? Like, to build that campaign where you get that level of consent, that looks very different than just texting a keyword to a short code, or giving your number where you don't have all of those required disclaimers. Yeah.
Wow. Okay.
So it depends on where you want the pain to be.
Yeah.
Front end
or the back end.
Right.
Yeah. Interesting. But I think, first off, always consult an attorney, because, as you can see, this is not as just black and white as it could be or should be.
No.
This is a lot of complexity.
It's definitely one of the grayer areas in the TCPA.
Okay. Well, it's good, though, that we've at least kind of broached the subject of what constitutes a marketing message versus informational, and why do marketers even care? Mm-hmm. So, and that's the answer to what is the difference between a marketing text message and an informational text message. Again, my name is Derek Johnson with Tatango.com. I'm here at Innovista Law with the TCPA Defense Force, and I'm here with Joe Bowser, a TCPA attorney. Thanks for watching our video today. If you like this video, be sure to give us a thumbs up on YouTube. If you want to see more of these types of videos, be sure you subscribe to our YouTube channel. And if you have comments or questions, please leave a comment or question in the comment section below.